Welcome to the Digital Planning Podcast. This series is designed to educate individuals about all things digital in connection with estate planning, business planning, and estate administration. To keep up with all things digital, please subscribe at iTunes, Stitcher, Google Play, or wherever you download your podcasts. And now, Jennifer Ziegel, a partner at Kleinbart LLC, Ross Bruck, a principal of Estate Genie, and Justin Brown, a partner at Pepper Hamilton LLP, with today's topic.
Welcome back to the Digital Planning Podcast. I'm Jen, and I'm with my co-hosts Ross and Justin, and we're here today to explore the ownership of digital assets, whether that be outright or in an entity or trust vehicle. There are a lot of different ways this can come about, and we're going to be looking at the pros and cons of each. So, Justin, if you have a client who comes in and wants to do some digital asset planning, and they're concerned about ownership or they're going to be purchasing new digital assets, how do you address the first step in the conversation?
So the first thing I do is I try to find out from the client if we're talking about new digital assets that haven't been created yet, that they're going to be creating or obtaining, or if they are existing digital assets that they have already purchased or acquired and is already in their individual name. Because I think our planning options differ based upon where we are in the ownership structure. So the first thing, if you have new assets, it's always going to be a lot easier to do the planning because we can establish our facts, so to speak, the best way we want them to be, right? We can establish an ownership scheme which is going to maximize the benefit of the digital asset. If the individual already owns the digital asset, we may have some restrictions. And specifically, the biggest impediment to doing planning with digital assets is existing terms of service agreements.
And why is that a problem?
Well, one of the problems with terms of service agreements is that they provide as to who can own the digital asset. And a lot of these terms of service agreements will just say you have the ability to own, or the contract is between us and you, but there's no definition of who you is. And in an individual situation, you is you, the individual user who is creating this account. So for example, let's say somebody has a Gmail account, or somebody's creating a Gmail account. And when you sign up to get that Gmail account, you put in your first name and last name and an email address. So the you is the individual who creates it. But what if we had the ability to create that email account in an entity or in a trust? It doesn't really work well in the form that Google has to set it up in an entity versus an individual.
And you might think that that was done on purpose in the terms of service, specifically to limit your ability to use an entity or a trust. But based on conversations we've had with people in the tech community, it doesn't appear that's the case at all. It appears that you was just chosen because it was the simplest form, and there was no real thought in a lot of the terms of service, not in everything, but in a lot of the terms of service agreements that we've looked at. There's just no thought being given to this long-term estate planning needs within the digital ownership of these assets or these accounts. And it was chosen as a default more than a active selection. So I think a lot of these companies, because they have, let's say, a lot of these companies have other things to spend their resources on and think about and devote their time to, especially when it comes to the terms of service. This is an afterthought, and unfortunately it leaves a whole lot of ambiguity in how to plan around that.
I completely agree, Ross, with everything you just said. I think a lot of the people that are creating the terms of service agreements for the various custodians and service providers are not thinking about long-term estate planning goals. And one of their biggest considerations is to simplify the definition of you and also include definitions within the terms of service agreements that the assets are not transferable. So no, they're not thinking about alternate structures that could be utilized to, in essence, have the asset or the account continue on in perpetuity if the trust is the you that's owning the account or the digital assets, which in theory can go on forever, and you could have different trustees and different beneficiaries benefit from the assets that are titled to the name of the trust.
But if you're an audience member and you're listening to this podcast and you do have experience with drafting terms of service or inside knowledge of the process of terms of service agreement drafting, we'd love to hear from you and get your comments on that discussion.
Yeah, absolutely. So from an estate planning perspective, one of the things that I look at if a client says they have a digital asset is I look at the terms of service agreement to see what happens to that digital asset when an individual dies. What happens when the quote you in the terms of service agreement dies. And what is very common in these terms of service agreements is that upon the death of the you, the individual, maybe the information that is being held by the service provider is deleted, or maybe there are restrictions on who may access it, or maybe there may be restrictions on what may be accessed. So as an estate planning attorney, what I want to do is I want to figure out a way to get around that problem. How do I get around the problem of we have this death triggering event where access and information is going to be limited? So one of the ways that I can get around that is if my owner doesn't die. And then how can I create a structure where my owner doesn't die? Well, one way is to create an entity to hold the digital asset. Or I could create a trust to hold a digital asset. So that when I create this ownership structure from the very beginning, I'm setting it up so that I will never have that access problem, right? I will always be in a situation where somebody, whether it's a shareholder, whether it's a manager of a LLC, a partner in a partnership, a trustee of a trust, somebody will always be able to get access to the information regardless of whether the beneficiary or one of the members of the corporation, the partnership, the LLC, regardless of whenever those people passes away.
To take that one step further, you also have the competing interests of the service providers that have provisions in most terms of service agreements that the terms of service agreements can be amended at any time. So when the initial planning is taking place to create an entity or a trust, or even an entity owned by a trust, if you want to have additional layers of protection or other planning needs that situation would address, you also have to be mindful that although it might be permissible or workable structure at the time all of this planning is being done, is there a risk that the terms of service agreements could change, which you're deemed to accept those changes if you continue to use the service, which would then make the planning structure, the vehicle, contrary or not permissible under the terms of service agreement. And in most terms of service agreements, if you are in violation of the terms of service, they can close the account or shut off access. So you have to be mindful that with this type of newer planning structure, there are some inherent risks that clients need to be aware of. On the flip side, maybe this type of structure would be grandfathered in with new types of terms of service agreements that might prohibit this type of planning.
Well, let's talk about the specific types of planning. Let's take a deeper dive into creating a business entity to hold these assets, or creating a trust to hold these assets, or creating a trust, a business entity inside of a trust to hold these assets. So let's first talk about existing assets that are in place. So if you have, let's just say, an email account, and you've got the problem of when you die, nobody's going to be able to access it the way you want it to be accessed. Or or maybe nobody, but it just won't be accessed. All the information won't be accessed the way we want it to be accessed. The big problem here is the existing terms of service agreement for some of these accounts. And a lot of these terms of service agreements will say that the individual's account is non-transferable, meaning they can't transfer it to a trust. They can't transfer it to an entity. And I think that we're pretty stuck in our planning for these accounts that are already in existence, because any kind of transfer would violate the terms of service agreement.
Yes, I completely agree. And I think that non-transferability is during life and at death. So planning now or even planning later, for certain types of digital assets, it could be very difficult.
So I think when there are people out there who have created digital assets trusts, and again, I would love to hear from people who have created these trusts, but I don't see personally how these trusts work for existing digital assets. I think they work for other purposes, right? There are digital assets trusts out there that could work to appoint a digital trustee or a digital executor, so to speak. But in terms of transferring assets to a digital trust, I don't see how it works. Now, for new assets, I think that's a whole new story. And I think, as kind of Jen said, we've got to follow the terms of service agreement. And maybe, as Ross had said, it's not necessarily, the providers are not contemplating putting these assets into trust, so they're not creating their terms of service agreements to contemplate this. And when you sign up for these accounts, it doesn't really fit into a trust, so to speak, right? So one of the questions is, if these terms of service agreements are arguably very vague as to whether or not trusts can hold these assets, what happens when they ultimately find out that your trust is owning these assets?
Yeah, and I think that goes back to Jen's comment that under the terms of service agreement, almost universally, if you are in violation of any of their policies, they can cancel your account or terminate or take ownership of any licenses that they have granted to you. And I think even from the moment you created a new account, you might run into that problem. A lot of accounts, I'm thinking of Google in particular, will ask you, if you create a new account, date of birth. And they're doing that in part because they want to make sure whether or not minors are using it, and that there's a differentiation between an adult and a minor using an online account. But in doing so, let's say you created the trust yesterday and you created a Google account for that trust today. When it asks you the date of birth of that trust, you can't say yesterday, because one, that's going to be deemed a minor's account because it's only 1 day old, and Google will put certain restrictions around it. You could possibly use the date of the trustee's date of birth, but that's not really what they're asking. You could make up a date, but that's also a violation, most likely, of their terms of service. So in all three of those instances...
Or the beneficiaries.
Or the beneficiaries, that's right.
Which could be a minor.
Which could
be a minor. In all 3 or 4 or 5 of those instances, that looks like it's a problem under the terms of service. And it's not a direct conflict with that provider's goals, but it nevertheless is a violation in most instances. And does that lead to a termination of the account from day one? Again, we go back to that original comment that providers just haven't thought this through. And so this will change and evolve, but in the meantime, if you've created that trust to serve as the entity that's going to hold that account, are you going to run into trouble down the road?
And also, what happens when this trust that you've created subdivides at some point, right? Maybe I've created a trust, and upon my death, it gets split into a marital trust and a credit shelter trust upon my death. How do we then register those? Right? Is that considered to be the death of the you in the terms of service agreement when you're parent trust subdivides into two separate trusts.
And what happens if you have two fiduciaries? What happens if you have two trustees, but there's only the ability to name one individual as the trustee or as the manager or as the account holder when you create the account? What happens then?
Yeah, is that a violation of password or account sharing if they share that type of login information? Should the trust also not subdivide? Should it be a pooled trust, a sprinkle trust, meaning that the trustee would keep everything in essentially one big pot and sprinkle out different digital assets or make in-kind transfers to avoid a sub-trust division issue? I also want to go back and clarify that we're specifically talking about digital assets that might be subject to terms of service agreements. For digital assets that are not subject to terms of service agreements, for instance, if you have Bitcoin and you own that and hold that individually, that wouldn't be prohibited from being transferred into a newly created trust. Those types of assets would be permissible. What we're focusing on are assets that are currently subject to terms of service agreements that the person previously owns before the trust creation, and then those types of assets that might be created post-trust creation.
So just to take a quick step back, I think that we are nitpicking a little bit and we're finding flaws in this system, partially because it's new and it's never been explored. I think, at least and feel free to comment your own individual opinions, this is a creative way it's a creative solution to work around the problem that we've all identified. I'd like to see it explored further. I'd like to see some of these details ironed out, but I still think it's a promising idea to use an alternate entity to solve for the digital afterlife problem.
So because of the problems with trusts that we've talked about, I don't use digital trusts in my planning. I think a better route to go would be having an entity own the digital asset and then maybe having a trust own the entity, or just having an entity own it. My feeling is that's a better way to go, because these companies may be more willing to accept an entity owning an asset than a trust owning an asset. Entities are more common, they're more familiar to these companies. So the fact that an entity own it, I don't think will raise as many red flags for some of these for some of these companies. The other issue for entities is that you can have a management structure that is perpetual in nature, that can continue to manage the digital assets and access the information, and it's probably less likely that your company is going to subdivide like a trust is going to subdivide. So you don't have the death issue that you have, or the potential death issue that you have in a trust, where the trust subdivides and, I'm putting in quotes, dies. So I like the corporate ownership structure a lot better than the trust ownership structure.
One more thing is that you also don't have an issue with beneficiaries and whether or not they should have access under the terms of the trust. I'm just imagining a trust that has complete withdrawal rights provided to a beneficiary at his or her decision, and does that mean that they should have access to the password for that account because they have access to withdraw anything, that even principal, from the account, and does that include this online account? I don't know.
But with the entity, you still have, in Ross's example, the issue with the birthday of the entity. Because if you created an entity and then tried to create or transfer digital assets or make a Google account or email account for the entity, you still have the birth date problem that Ross explained.
But you could use the manager of the LLC or the managing partner of a partnership. It's not a perfect solution.
Mm-hmm. Just things to consider.
Yeah. Well, I think that there are a lot of different solutions that we could use today to plan with our digital assets, and the hope is that as these issues continue to evolve and custodians are thinking about these issues, They'll be explicitly addressed in terms of service agreements, or there will be a lot more discussion of these issues so that we can plan around them.
Yes, we are definitely in new territory that there's not a lot of case law or statutory laws in place to govern this area, and the technology is going to ever evolve, and so this is just another planning opportunity to reevaluate every few years or as bigger technological developments become popular.
If you have any experience in planning with digital assets and using entities or using trusts, we would love to hear from you so that we can talk about planning ideas for our podcast. Feel free to email us at digitalplanningpodcast@gmail.com. Again, digitalplanningpodcast@gmail.com.
Thank you so much for joining us today as we fleshed out different planning opportunities with the ownership of digital assets, and we hope you continue to stay tuned as we explore further topics connected to all things digital in estate planning and business planning. Thank you.
Thank you for listening to this episode of the Digital Planning Podcast, the podcast designed to educate individuals about all things digital in connection with estate planning, business planning, and estate administration. Please subscribe to this podcast and leave us a rating or review at iTunes, Stitcher, Google Play, or wherever you download your podcasts. Thanks for joining us. We'll see you next time.